Good afternoon, everyone. And once again, thank you for joining this webinar. And apologies for starting some few minutes late. We wanted to enable everyone to join and start together. So, today I'll be your moderator. My name is Praise Joseph. And today we are having the session on the role of legal profession in supporting the business and human rights agenda in East Africa. And in this session, we have our three panelists. We'll have Ms. Asmahan Said Ochiel, and our last presenter for today will be Mr. Cyrus, the Deputy Director of the Kenya National Commission on Human Rights. In the reflection of today's webinar, it will be a series of looking into the East Africa and how, as a region, we have come to undertaking the current trend of issues of connection between business and human rights. And according to the recent developments and trend, we have seen most of the actions in the business sector have direct and integral impacts towards human rights, such as the development of oil and gas and other investment sectors, which has impact to the community. And now, as the legal fraternity, what is our role in ensuring that we protect human rights, but also in that area, we continuously advise our clients who are in the corporate world into how to deal with their business, but also ensure that they protect human rights as they go along. And starting, we'll have the first speaker of today, where I will welcome sorry about that. So today our first speaker will be Ms. Asmahan Said, where she's the managing partner of KTA Advocates. Where our first speaker will be Ms. Asmahan Said, where she'll give us a background understanding on business and human rights, but also she'll give us a practical case studies on how corporates have been handling issues of human rights, and give us a case study on how, as legal lawyers, how we should continue our ethical practices, but by ensuring that our corporate world protects human rights as well in the community that engages with them. Thank you.
Can you hear me?
Yes, we can. You're very audible.
All right. Okay. Thank you so much. Praise God. Thank you so much for the introduction, and also accepting to chair this session. To my panelists, thank you so much, and welcome to this session. To the members who have joined in, thank you so much for taking out your time to join us in this conversation. I am no expert, so I'll just disclaim that I am not an expert, but I have very keen interest in this area of practice, which I'll keenly share. And so I'll just share from my knowledge and part of what I've experienced as I encounter business and human rights. So thank you so much, members, for allowing me to be part of this conversation by joining. Thank you so much, the East African Law Society, for always being gracious and, just ensuring that we are kept abreast of what is happening. It's a great opportunity to see that knowledge is being shared in such ways. So thank you so much. Once again, my name is Asmahani Saad, not Said, but it's Saad. I'm the managing partner at KTA Advocates, and I also do wear a couple of hats as well in the governance space. I sit on a couple of boards, private and government. I also do a lot of mentorship and community work. Part of my life, I love also serving in my community. So that's me in a nutshell. Thank you so much. So in case you have any questions, you can just put them in the chat box, and then when I'm done, we'll have a Q&A, and we'll be able to just ensure that at least we come out of this with one or two things. So let me just get right onto it. I have a presentation, but allow me not to strictly go by it. I just want to speak through it. I will share this with the ELS Secretariat, who will be able to share it with all the members that are interested would have it on hand. So, you know, you can just keep reading and understanding. So I'll just right away get into it. So basically, when you look at business and human rights, it's one of those things that most times people kind of want to separate business from human rights, in as much as businesses are run by human beings and encounter human beings. But it's one of those concepts that inherently the two don't seem to connect, because when I come to do my business, we're in a capitalistic world, at least for Uganda. I just want to come, invest, make my business, make my money. Yeah, I don't want to care so much about what impacts or what surrounds me, you know, that's just my bottom line. But, and as, you know, history evolved, you'd see that human rights was more of a state or government issue, sometimes assisted by those non-government organizations, but it was more of that bigger, enormous issue that for us, people in businesses, small, medium, or large enterprises, we really don't want to know much about it. But yeah, the state and all, you know, be there with your agenda, and we will stick to what we know best. So it's that convergence that later on the need, you know, the need for a highlighted approach into merging this to the business component of it, and then also looking at human rights, because like I said in my intro, businesses run with human beings, businesses are done to serve human beings, the communities, everything around the business has human beings. So that is just the introduction to just break down the concept of business and human rights. So the United Nations, once upon a time, thought through this and said, okay, we have this obligation to critically look at this. And the genesis of this, if you somehow get to understand the historical evolution of man through business, the first industrial revolution, second, third, fourth, a lot of impact was happening. In as much as economies were recovering from wars and things like that, there was a trail of impact in regard to human interaction with business that was happening. And so there was need to interrogate and see how do these two converge. And so UN was one of those entities that really took time to interrogate and internalize this. And through that, they came up with guiding principles. So these principles, the UN guiding principles, they are on the internet, the information is there. So they are UN guiding principles on business and human rights. And specifically, these principles looked at, I'll just highlight a bit, three things. One is, you know, for the state to critically look into and highlight business interactions with human beings, even state as well, because you realize states as well do business. States as well develop, they do projects. It is the mandate for the state to cater for its people and its citizens. So infrastructure development, these things will happen either through state or through private entities. And so the first highlight of these principles is that the state has the obligation to protect the human rights, the rights for the humans that they interact with, respect them, and in case there is any form of infringement, be able to remedy those. And then of course, now we're going to the second layer is to see that the UN business and human rights is pushed down from state's obligation to enterprise obligation. And so in this kind of framework is to see that businesses, as they interact and do their business, they must be an awareness of how the business is interacting with not only humans, but the general surroundings, environment, anything that can impact the ecosystem or survival of a human being. So you're looking at environment issues, you're looking at water, you're looking at climate and all these things. And so the last portion of it was that these rights have to be critically looked at, and then we have a formulation of remedies that speak directly into the aspects of infringement. And so that is also another aspect of it as we get into these discussions. What we need to note is that the UN guiding principles, just as I've resounded them, they are guiding principles. They are not law. So most times they are meant to entice or, push this agenda and make sure that the state and enterprises within the states get to adapt the business and human rights awareness and also start implementing these things. The other component of it that I would quickly highlight is, so out of the human rights guiding principles, of course, a lot of international kind of legal framework came up. And of course, through UN and other, international bodies, we see that most of them, or most specific parts of these rights were pulled out, and specific protocols and guidance notes, guidelines, and things like this were developed. And I'll just mention 2 or 3, so I can skip the a lot of legal jargon. So one, it's the International Convention on Economic, Social, and Cultural Rights. And specific to Uganda, this is something that we've adopted, we've ratified. We haven't yet, domesticated, but it is one of those things that really guides how businesses incorporate. So you have the economic component, you have social, and you have cultural rights. And to bring it home, some of these things, when we look at some projects, infrastructure development, the oil and gas projects, a lot of the social and the social studies that are being done, the ESEA, which is the environment, social impact assessment studies that are being done, most of them are standardized and based on some of these protocols on economic protocols. You have culture, where you see that specific cultural entities, well, they could be entities or they could be marks. For example, in Uganda, there was an interesting scenario that we had where there was a specific tree that people believed gods resided in that tree. And so when the Uganda National Roads Authority wanted to have a right of way around that specific tree, it became a national phenomenon. So, the gods had asked for specifics to be done, and it became really a debate. And you see, we need the infrastructure, but yes, there is respect for culture. And so at the end of it, I remember seeing an article where an institute, I don't remember, somewhere in Europe, had come up with a solution. They pull out the tree, with all its roots and replant it. And so that kind of debate is how deep business and human rights can go. Then when you look at continental and a continental outlook quickly, you see even in Africa as a continent, there are key highlights or key aspects of business and human rights that have been adopted. One is the African Charter on Human Rights and People's Rights. Some may be aware of it or not, but this is also known as the Banjul Charter. Specific the enforcement of rights. There is an African Charter on Human and People's Rights Court that sits in Arusha. And so most of infringement, civil rights and all these things, they can go up to the implementation and execution and remedy the whole 360. And this is from the African dynamic. And then there's the Protocol of African Charter of Human and People's Rights on the rights of women. This, of course, applies to women's rights. And of course, I want, as we go through this journey of understanding business and human rights, is to know the history. Like I said, when we look at the historical perspectives, all the industrial revolutions, women were really, really marginalized at that time, you know. Opportunities were less. And so most of these protocols came up to address some of these issues from a human rights perspective. And so I'm going to quickly dive into a highlight of the East African Business and Human Rights Outlook, just to hint on some of what the East African countries are doing. Kenya, and I know on the call we have so many Kenyans, please, if you have anything more to add, just use the chat box. And we can really have a good debate and understanding of this. So of course, the Constitution of Kenya mandates and obligates the respect of human rights. In the Bill of Rights, of course, you have environment and human rights through the full cycle of human beings and the environment, how we survive. So you have environment issues, water, community, and so the Constitution mandates that these rights should be respected, and so relevant laws should be made to see that protection of these rights is done. With the United Republic of Tanzania, there's a primary law that has a Bill of Rights, which businesses are expected to respect. And so some of these are highlighted, for example, in the Mining Act of Tanzania, which was amended in 2017, the Land Acquisition Act, and so forth, and so on and so forth. And then in the Republic of Rwanda, the Bill of Rights provides that, you know, every Rwandan citizen has a right to a clean environment, to join trade unions, to protect their economic rights, and so on and so forth. So that is from the East African perspective. The Republic of Rwanda, again, the Bill of Rights in the Constitution guarantees freedoms against discrimination from any sorts, slavery, servitude, and all these things that really run around labor laws, environment laws, and so on and so forth. And then, of course, South Sudan, the Bill of Rights that, guarantees freedom from discrimination, access to information, privacy, and so on and so forth. For the Ugandan perspective, which I really wanted to also kind of highlight more because this is home for me. Of course, we have our 1995 Constitution with a clear Bill of Rights in there, protection, promotion of human rights. We have Article 21 specifically highlights economic, social, and cultural rights. Article 40 also goes on to expound on the economic and social rights that are entitled to every Ugandan citizen. We have a Human Rights Enforcement Act in Uganda. We also have laws that have been put in place specifically, like the Persons with Disability Act, the Workmen's Compensation Act, Occupation Health and Safety, and so on and so forth. So that's just a perspective of, okay, I still have still within my time. That's just a perspective of business and human rights, from the historical, how it developed, the African context of it, the international African, East African, and the Ugandan. So with Uganda, we actually started a conversation which was picked up by the government actively. And so with that, we now have a signed off and formal and active National Action Plan on Business and Human Rights. And this really builds onto the principles of business and human rights and really focuses and highlights on how Uganda plans to achieve compliance with the principles, the guiding principles that are laid out by the UN. So the framework was developed by multi-sectoral efforts. There are a couple of ministries that joined hands to develop this. A lot of stakeholders. Like I said, all these are strings from the Constitution. So you have the Ministry of Labor focusing on economic and social rights, Human Rights Commission, Equal Opportunities Commission, and so on and so forth. I don't want to really get into the details of this, but I will share these slides. So from the Ugandan perspective, and yes, just to add on, there is a national action plan stakeholders that have been formulated. And for example, we have, these stakeholders have been given key tasks to ensure that the national action plan is being followed. And so we have, for example, when it comes to specific stakeholders like Ministry of Gender, Labor and Social Affairs, one of the key things they have to do is to monitor human rights compliance by businesses. So already that's a role that has been distributed. And so this national action plan, of course, on paper, when you read it, it's wow, it's very well thought through. You can see that you can really pick up on the discussions. You can see the spirit of business and human rights in there. And so it's one of those things that are really, really good on paper. However, like any other law or anything that we run, I think it's not just in Uganda, but most of African countries, enforcement, there is a bit of issue. So right now, from 2016 to now, when we had the National Action Plan put in place, we see that, of course, there are still gaps in enforcement. All these things that were highlighted, awareness campaigns that are supposed to be done around business and human rights, they are still not where we are supposed to be. Of course, when it comes to remedies, the biggest challenge that we face, again, access to court, judicial processes, the cost of accessing courts to for these remedial actions. Again, we still have a lot of glaring gaps in there. And then we also see these continuous violations, things like child labor. We've had a couple of documentaries that have run, highlighting the mining sector especially and what is happening in there. You see children working, of course, women, persons with HIV, people with disabilities. So again, there is still a lot of violations. So that means there is need for more awareness, but also a lot of effort through government and its key stakeholders, but also other supporting stakeholders within this. Before I go to the way forward, so now I just want to drive it home. Of course, this topic touches home because as lawyers, we have a specific role that we have to play. And I'll talk about it in two parts. One, lawyers as advisors, but also as lawyers who are running businesses, who have a role to play in the actual respect or, the remedy or, the whole BHR thing. So to recognize, to respect and remedy. So we also have a role to play as lawyers who run businesses through law firms or any other kind of organization that we run. So that's really the angle for lawyers. So one is as businesses in the business operating or ecosystem, what are we doing ourselves within our organizations to see that business and human rights is highlighted? The other angle, like I said, is how do we incorporate in our advisory or when we go out there to talk to our clients, government, advocacy, how well are we pushing the agenda around business and human rights? So I'll first kind of take a deep dive into the business enterprise of law firms. Like I said, I run a business as a law KT Advocate, which is a business selling the products of law. But regardless, we still have the obligation to respect human rights, from the context of us as business owners, but also the people that are within the operating system of our businesses. So one, are we aware that we need to access human rights impacts within our businesses. For example, occupational health and safety, issues around hazards around businesses, protecting, our associates or people going to work. Are they having the right kind of transportation? Small things like that. And then also as a firm or as a business, through that awareness is to make commitment to actually highlight human rights or compliance to human rights within the business of the law firm. Following that, you need to have policies, actual policies. And key is, for example, an HR manual. How do you employ people? How well are people's rights being respected? Do people get leave? Do they get time off? Are they well compensated at the end of the month? Issues around social welfare. So these are very, very key to be highlighted in starting with us, starting home. And then, of course, like any policy or documentation or the way you'd want to run your businesses, communicating it to the staff, ensuring that there's compliance and constant review. And the review is really based on what is happening around the ecosystem of business and human rights. So that awareness and keeping in touch and knowing that there is a connection between us as law firms. Sometimes I know lawyers being lawyers, we want to kind of disassociate ourselves from the business setting, but we are a business and this is really very key. The other part, like I said, is how do we then incorporate our business and human rights into our advisory to clients? Of course, the first thing is to have these conversations with companies. And I'm not talking about the big companies, oil and gas or infrastructure development companies, energy, no. It is throughout the whole enterprise system, value chain, from the micro, medium, small, large enterprises. There must be an awareness that there is the importance of recognizing, respecting, and if any human right has been infringed within the company operational environment, then it has to be remedied. So this is very important. So having those conversations from management level, if you're a lawyer and you happen to perhaps, have access to the boards, this would be a very, very important topic to share with board members. I know these days there's a key component that has been drawn out of the whole business and human rights angle. And of course, we're looking at elements of ESG, which is environment, social governance. We're looking at climate change in totality and how businesses, the emissions of businesses, the carbon credits and so on are becoming a very, very key factor in the operation of businesses. So depending on where you can fit and have a conversation, it is important that the general overview or the framework of business and human rights as a whole is brought to the front as well. Then, of course, the clients that we have in supply chains, logistics, transportation, there's a lot of impact that happens in there. And sometimes because some of our clients are crossing borders, they're moving from one jurisdiction to another, it might not be something that they would quickly want to adopt, but it's important. How are you interacting with the environment, the people, the social aspects, it's also very important. I think I've hinted on this. Of course, our best ally are the company secretaries or the legal counsel in the different companies. So if you have this kind of reach, it is important that you have these conversations. It is important to take a deep dive into the company policies and see, are these policies business and human rights friendly? Is there a way that we can engage and see that we quickly adapt to ways within which this company can now be more aware? And of course, slowly by slowly, I know a lot of companies take initiatives like corporate social responsibility, which is very good. Companies now have, with the sustainable development goals, with the emergence of the green economy, which comes to financing of different businesses, there's a lot of awareness. And so it goes without saying that the whole dynamic of business and human rights is lingering. But my feeling is that bits and pieces of it is being taken off the whole totality. And so it is important that even as we, get into these discussions, perhaps a company is really now interested in green economy. How do I turn around my company to meet the requirements of a green company so I can access this green financing? Because it really comes, it's cheaper than the other modes of financing. But, not to just focus on that element of the tail end. Like I said at the beginning, businesses, we just want to look at the bottom line. Like, don't tell me many stories. It is important for us as business and human rights lawyers to start that conversation, not only just focus on how the company can green itself up to access this financing, but how do you drive back the conversation to the totality of business and human rights? So that's really important. Companies' agenda, board agenda now, ESG is everywhere. Everyone is talking about it. Companies are being measured, especially public companies. They're being measured on, their compliance around environment, social governance, how well the companies are, effectively, taking care of the environment, social aspects in and out of the company, and so on and so forth. But like I said, my feeling is that these are smaller components of business and human rights, and it is our role to just bring it back home and have a full-fledged development and discussion around this topic. So yes, I know the bottom line, how do we make money? Like I said, there's really opportunity. There is a lot of opportunity. Advisory, yes, like I said, there is so much around business and human rights. And it is good to look at the different components, ESG, green economy, carbon credits, how to become more carbon friendly, how are we emitting? But that is more of the bigger angle. The smaller angle, the bigger conversation is we need to see that we have specific advisory or expert advisory coming out of this. If you look at the projects that are running now, oil and gas projects, mining, infrastructure, which are ongoing projects anyway in Africa and East Africa, because we are still developing, there is really, really an opportunity. I'm talking about specific or expert knowledge on environment laws, where you can advise your clients around environment and how environment interacts with business and human rights. Social aspects, labor, and all these things. It's really, really full-fledged. So my advice would be that we get knowledgeable, we get to understand the trends and what can we capitalize on. Like I said, right now it's all about ESG. It's all about the greening up the economy. It's all about conversations around climate change. So in regard to climate change, what are those specific components that you can address within your business environment? It's more about the dynamics that have changed in the way people work. Employment is now changing. How are you going to advise on that? Because regardless of whether someone is working home, working physically, and they're still under an employment or contract of employment, there are also rights that need to be recognized there. And so with lawyers, I think, and I believe it's really an area of keen interest. It's an area that we need to really, really get knowledgeable on. I know that there are a lot of programs that are being run by advocates for international development, that FOID. East Africa Law Society also runs a number of campaigns and knowledge-based workshops. There's a lot on the internet, so I would advise that we just get more knowledgeable. So lastly is just our way forward. In my view, and from what I've presented, I think there are critical things that we need to look at. Of course, there's so many challenges I've talked about, but challenges always give us opportunities, right? So it's to look at how do we now turn this around. I've already talked about the benefit of us as lawyers in understanding and addressing our minds to this thinking topic. But a way forward from what I had previously presented, of course, we need to strengthen those conversations between the government agencies, to just see that we act as middlemen. in a way, because that's our role as lawyers anyway. We are facilitators of the law, we are interpreters of the law, we are in a way people who give way to enforcement of the law. So how do we have those continuous conversations to make sure that the business and human rights aspect is well understood by government itself? Yes, yet the ones who make these laws, but that continuous conversation and of course the implementation of it. Then of course, with government, it's always about resources, you know, if implementation and resources go hand in hand. So again, with the awareness campaigns that run, part of the campaigns is to see that we have actual allocations of revenue of government putting, you know, actual revenue into the business and human rights to see that the whole aspect of it is fully, we can fully benefit from what this is all about. Of course, sensitization, I've talked about that. How can we simplify information? I know even us among lawyers, I mean, you talk about business and human rights and everyone is like, huh? It just sounds so, you know, but yet it's something that we interact with on a daily, you know, with through business, through advisory, like I've said. So how do we ease the flow of information? But most importantly, how do we speak the language of business and human rights, which is everyone's day-to-day life, I must say, to make sure that there is a buy-in and that people can actually, you know, intentionally walk that journey of having an awareness, implementation, and see how business and human rights, you know, is just part of business. Of course, like I've said, we need support, intergovernmental support, you know, interventions, and so on and so forth. So I think I've maybe overshot my time by 2 minutes. Praise God, I'm sorry about that, but I would like to end there and hand over to you. And I look forward to the interactions that follow. Thank you so much.
Thank you so much, Asman. Thank you for the good presentation. As you have highlighted and showed us the different legal frameworks governing different countries in East Africa, and give us a light of how us as lawyers can take advantages of the situation, but also the relevance and importance of us to gain knowledge and information around issues of business and human rights, but also how it doesn't only affect our clients, but also it affects us in the different areas that we encounter, especially most of us, some undertake business activities personally and not just on behalf of our clients. So looking at the bigger picture and how you have given and highlighted the existing challenges, especially reflecting mostly in Uganda, but also showing how other East African countries encounter such challenges, we would like now to move to our second speaker, Mr. Cyrus Mawiu, who is the Deputy Director at the Kenya National Commission on Human Rights, where he leads the Commission's work on economic, social, and cultural rights, but also he has diverse experience in the human rights and social justice sector. So Mr. Cyrus will give us a clear understanding of how business and human rights have been encountered in Kenya, but also give us an overview of how practically other East African countries have encountered issues of business and human rights. Mr. Cyrus, welcome.
Thank you very much. Praise God. I am going to walk us through the context in Kenya, but allow me to start by introducing myself. As already pointed out, my name is Cyrus Mawiu. I work with the Kenya National Commission on Human Rights as a Deputy Director, where I am currently leading our economic, social, and cultural rights unit. And this is a unit that plays a lead role in matters business and human rights. Many times we keep wondering, and the first speaker has already pointed this out, why it's important to have this link and to clearly appreciate the business and human rights nexus. But I'll just highlight 3 things before I go into the discussion for the day. One is a simple appreciation that virtually all business interactions are with human beings, and to the extent that businesses are interacting with human beings, then there is a possibility that there might occasion a human rights violation. Again, if you look at the bottom line of a business, and this has already been pointed out, businesses are very keen on being in business. But any business that does not respect human rights actually threatens its very own existence, in that it will not be able to sustainably be able to realize the bottom line, which is making profits. There are a number of cases where businesses have been sued, and in the Kenyan context, the law allows, or the the Bill of Rights applies equally to businesses. So there are cases where businesses have been sued and they've ended up spending much more than what they would have saved if they upheld human rights. And then we also have every now and then threatened and actual consumer boycotts on allegations of human rights violations by different businesses. So globally, there's been quite a robust discussion on matters business and human rights. The United Nations Guiding Principles on Business and Human Rights provide a good starting point and a good context for different countries to look at how best they can domesticate the United Nations Guiding Principles on Business and Human Rights. And they also quite clearly articulate the different roles of both the state and the business in the 3 pillars that underpin the United Nations Guiding Principles. The state obligations are quite clearly spelled out, and so are the obligations of the different businesses. And we've seen quite an uptake the world over of these United Nations Guiding Principles, where different countries are looking at how best they can domesticate and how they can operationalize the United Nations Guiding Principles. Kenya is one of those countries that has already domesticated the United Nations Guiding Principles by developing and adopting its own national action plan on business and human rights. Within the East African region, allow me to share my screen now. I don't know if you can see.
Can see it, Cyrus.
Yes, we can see. Cyrus, I apologize. I was just enjoying looking at my screen. Sorry.
It happens.
I apologize.
So Kenya, amongst other East African countries, is already trying the best it can, of course, with the challenges that it goes through almost on a daily basis. But it prides itself as being the first African country to domesticate the UNGPs by developing a national action plan on business and human rights, and I'll be sharing that briefly. But basically, the national action plan is a way to look at how best we can apply the United Nations Guiding Principles in the domestic context. And we are looking at basically the 3 pillars, where the state has the duty to protect human rights, and this it does through a number of interventions. This could be through developing policies, and the National Action Plan proposes a number of policy actions that should be put into place to ensure that as a country, we have or we ensure responsible business conduct. And there is also the proposed development of different regulations to operationalize different aspects of the United Nations Guiding Principles on Business and Human Rights. Under Pillar 2, the businesses or the corporate sector is expected, at the very least, not to violate human rights in whatever it does. It can go on with, the businesses can go on with their business. They can keep investing, realizing profits, but in so doing, they should not occasion human rights violations. But that is just idealistic. It's what we all aspire to have. But the reality is that once in a while, even when the state does the best it should, the corporate is doing the best it should, there will be some few violations here and there, and that is why the third pillar is as important as the first two pillars, and this is where access to remedy is very crucial. And as advocates, we have a privileged position in the society. We have a point of advantage that we can leverage on to support access to remedy, and I'll be discussing that in a short while. Our National Action Plan was born out of very extensive consultations, and in these consultations, a number of concerns were highlighted, and this paints the context of the business and human rights sector in Kenya. And I'm going to just highlight a few of these, and then I'll be happy to take and provide clarifications later. One of the things that Kenyans were concerned, but before I go into that, allow me to point out that there was a national baseline assessment that was meant to paint a picture of where we are as a country in matters business and human rights. The business sector was consulted, and so were different civil society organizations as well as members of the public. And these consultations were to just paint a picture of where we are as a country, what are some of the critical issues that we felt needed to be looked at from a policy intervention, and what would be some of the interventions that would be or that were proposed in that context. So from the public consultations, which were held at different regions within the country, Kenyans identified 5 key thematic areas that they felt needed to be looked at holistically if the business and human rights sector were to ensure responsible interventions and responsible business contact. The first item that was identified, which is still a key concern in the country, is the question of land and natural resources. We've been told a number of times how emotive land is, how important land is to the different investments that people make, how important, how critical land is, especially to the extractive sector. And the concerns that were being raised were around questions of compensation. If you are to invest as a business, who do you consult? And we have cases where some projects have actually stalled due to or on account of lack of adequate compensation. I have in mind the Lake Turkana wind power, where the community was concerned that those who were consulted did not actually represent their interests as a community. And this is a problem that we continue having, and it is worse when we are discussing consultations and land in areas that are occupied by indigenous people, because of the various ramifications this has on their rights, including the right to practice religion, the right to practice their culture, and land is actually a source of livelihood for most of these communities. Then there were also questions around revenue transparency. Kenyans were, and we are still concerned about how we can achieve this. We have various investors, various businesses who would invest in the country. We don't know what they are realizing in terms of profits. We don't know, even if they were to present a certain percentage and as that which is due to the host communities or even both the national and county governments, unless there is that disclosure, unless there is that conscious and direct awareness on how much they are realizing, then there would be no meaningful way of holding them to account. There were also questions raised around environmental protection because of especially the harmful impact some of these businesses would have on the environment. Questions around loss of biodiversity, environmental pollution by the different businesses, and how best that could be well addressed or well taken care of. One other thing that is worth highlighting is the labor environment in Kenya. It's still a big problem. It was when we were developing the National Action Plan. it might be even as we go towards implementation and review of the National Action Plan. Part of the challenges is low levels of awareness on labor rights. We have a lot of undocumented labor. People would seek employment, they're still seeking employment, and there is no documentation that the employers are giving. There is no adequate or proper and effective regulation, especially of the recruitment agencies. Every now and then we keep receiving complaints from especially our sisters who seek employment as domestic workers in the Middle East. And I'm sure this is not a problem that is unique to Kenya. It's also very, it's also a very big problem, especially within East Africa, including Uganda and even Tanzania. We keep hearing of all these complaints, and it still remains a challenge how best we can ensure that at the very least that the businesses that are involved in recruiting for labor migrants at least take a portion of responsibility when these problems arise. Then we still have discussions around access to remedy. The UNGPs contemplate this. The National Action Plan equally prioritizes access to remedy as one of the key things that needs to be done both by the business and also by the state. The first speaker already highlighted some of the challenges. Even limited access to the courts when you have a problem, when a business has violated one or two of your rights. It's not very easy to access some of these courts, even physically. Even the costs that are involved, if you have to seek legal representation, filing some of these cases in court. We have a number of businesses that are engaged in uncouth practices, including intimidation of human rights defenders who are engaged almost on a daily business in defending human rights, in pointing out where they are not doing wrong, where they're not doing right, and also in seeking accountability and supporting victims of the different human rights violations in their quest for justice. The National Action Plan itself highlights a number of, or proposes a number of policy interventions at each of the pillars meant to ensure that the businesses do not violate human rights, and the state, at the very least, provides that environment where responsible business can be pursued. Allow me to highlight the role of advocates in all this, what I see as some of the roles that advocates can play in ensuring responsible business conduct. And part of what they can do is in their advisory role, and these cuts across whether the advocates are working for the businesses, whether they're also working for the state, because the state itself is also doing a lot of business. The state is employing advocates in different departments, and it is expected that in discharging their obligations, in their daily engagements, in their daily advisories to their employers, the advocates would guide their employers to complying with what their obligations are. If it's the state, the advocates can guide on what exactly the state should do, and this could include the development of tools, conducting different audits for the state, because the state is also in business through a number of its departments, through a number of its parastatals. So the advocates who are working for the different public organizations can guide the state in developing tools that would break down what the role of the state is. When we say the role, the state has a duty to provide the legal framework. How best can we go about that? And the advocates would do a lot of justice if they could prioritize this in their various advisories. The state also is a consumer of different services. It does a lot of procurement. So how best can the advocates who are working for the state leverage on this to advise the state on how it can ensure responsible business conduct in also part of its public procurement and how it sources for the different services and goods that it consumes as a business. And then also the development of various tools, especially for the countries that already have developed national action plans. How best can we, as advocates, in our different capacities, support the state in fulfilling the policy actions, the different obligations, the different tools? For instance, when we discuss human rights due diligence, what does it mean? What are the tools that we need to develop, and how can the state go about that? In terms of access to remedy, as I'd already pointed out, advocates are already at a disadvantage, at a position of privilege, in that many people look up to them. Those who have experienced violations look up to the advocates to support them in their quest for justice. And it would be very important as advocates if we can leverage on this opportunity and this position that we have in the society to support access to remedy in the different ways in which we engage in these. For those that are in private practice, I'm sure you can support the clients that come to you from a business and human rights perspective. And also for those who are in public service, public interest litigation has been one of the tools that we leverage on to enhance access to remedy, and also supporting access to justice through the other avenues that do not necessarily engage court action, including mediation. If it's a business that has occasioned violations, how can you support that business when they seek your advice? Even when they've been sued, how best can you support in a victim-centered approach to justice to ensure that at least those who have suffered these violations have some sense of substantive remedy? Then a number of businesses are developing operational grievance handling mechanisms, and the advocates would play a critical role in supporting these and also guiding the businesses in ensuring that whatever mechanisms they come up with, that these mechanisms are actually functionally efficient in providing a remedy, and a substantive remedy at that. Let me stop at that, and thank you for the opportunity. Back to you, praise God, and I'll be happy to take questions when the opportunity presents itself. Thank you very much.
Thank you so much, Mr. Cyrus. And linking it to the previous presentations, you can see that we have identified that most of our East African countries have the National Action Plan, which provides clear indication of how corporates and states should be protecting or ensure the protection of human rights. But also they have both highlighted how there are existing challenges that result into issues that violate human rights by the corporate, but also by state. And through their discussion, they've also said that we as lawyers have different roles to undertake to ensure that there is protection of human rights by both corporates, but also by state. And the challenge that they have all identified is the enforcement of existing laws, but also the existing policies and action plans in the state. So now we go to our next panelist, Mr. Ochiel Dunbi, who is a public law jurist and a Supreme Court of Kenya practitioner. He's also currently assisting Katiba Institute as a senior litigation and research counsel. With his experience, he'll highlight to us the different remedies available as lawyers that we can undertake towards ensuring that there is protection of human rights, but also towards ensuring how best we can advise our clients, the companies, but also states, into ensuring different activities that we undertake protect human rights in the region. Welcome, Mr. Ochiel.
Thank you, Praise, for the introduction. I think we've gone quite into some depth on the material already, and I won't be long. I'll highlight a few instances of the remedies Cyrus speaks about in action. For those of us who followed the news, in February this year, we had the dismissal of a case against Total by a French court, Total, the energy company, alleging that Total's oil project in Tanzania and Uganda violates human rights and threatens the environment. That's one exploitation of the judicial route to remedy to ensure that businesses comply with their human rights obligations. In Kenya, we've recently had a case filed against Facebook, alleging that Facebook failed in its human rights obligations and fueled the Ethiopian conflict by its failure to moderate content, insightful, hateful content published on their platform. The case is still progressing slowly through the Kenyan judicial hierarchy. A few years back, we had the Serengeti case when Tanzania tried to build a highway through the Serengeti National Park, and the EACJ stopped it, and the EACJ Appeals Division affirmed the decision, saying that the court must strike that balance between protection of the environment and the state's right to development. We've had something not so dissimilar recently in Kenya, the Owino Uhuru lead poisoning case, where a private company engaged in the recycling of motor vehicle batteries, car batteries, caused pollution around the environment, poisoned the water, poisoned the soil, had people dying from lead poisoning, children stunted, and things like that. And the matter went to the Kenya's Environment and Land Court that found the business liable and the government also liable for its omissions. Went to the Court of Appeal, which has recently ordered that business to clean up the environment and also imposed remedies against the government. Now, that's something that could have been avoidable had the private business conducted its human rights impact assessment. And so these things that Cyrus has spoken about and have an impact at the end of the day because of the protect, respect, and remedy framework. If the government fails to protect and the business fails to respect, then it has an obligation at the end of the day to provide a remedy. We've had two famous rights to housing and the freedom from forced eviction cases going all the way up to the Supreme Court of Kenya. William Musembi and another case called Mitubel, where there were questions about balancing the rights of a private landholder against the rights of settlers living on that land. And the school saying, the private landowner saying that we have no obligation to provide housing to these people. But the Supreme Court was able to recognize the negative obligation to respect, which is an obligation of result, non-interference. Do not interfere with the right to housing by instructing the police or anyone else to evict the people who are living on that land. Another case in point, a case study, is a Lamu coal-powered energy plant case, which we argued a few years back. There was a plan to build a $2 billion power plant in the Lamu site, next to Lamu. And Lamu is actually a UNESCO World Heritage protected site with endangered flora and fauna. And we went to court for that. I see Marco Daga on the platform. He was involved in that case as well. And that project was stopped. There was a claim that, Kenya has an energy deficit and that generating power from coal would be good for business, would bring down the cost of living because we would be able to exploit cheap energy. But then that had to be balanced against the environmental concerns. The local population losing their fishing grounds, their rights to culture being impacted by the migration inward, and then of course the environmental threats that would result from building a coal project within a UNESCO protected World Heritage Site. I think the administrative remedies have largely been covered by Cyrus. I could just maybe point out a few of the principles that would bind those kinds of administrative remedies. They must be legitimate in terms of they must be trustworthy and able to give people effective solutions. They must also be equitable in terms of fairness and must be transparent in terms of supplying information to those with grievances. They should know how to access the remedies. They should, of course, be accessible and give predictable outcomes. You should know how long, for example, it will take you to file your case, where you need to file it, what you need to do about it. And one thing that cuts through is that this issue deals with the imbalance of power between private persons and businesses. And so some of these mechanisms, whether judicial or legislative or administrative, might not be as accessible to those whose rights are affected. The Owino Uhuru case, for example, was about a lead factory built within a slum. These are already people who are poor. And without assistance from lawyers like you on the platform, might not be able to access any kinds of remedies. So just to re-echo what was said before, lawyers can assist through public interest litigation and through pro bono engagement. Pro bono, funnily, does not mean for free. It comes from the word pro bono publico, for the public interest or for the good of the public, pro bono publico. And so those of us who are able to can take some of these cases pro bono publico, for the good of the public, because often those who cannot afford a lawyer the most are the ones who need it the most. You've been evicted, you have a job that can barely feed you, and you've been evicted in your thousands. Mitu Bell had about 6,000 evicted informal settlement dwellers. William Musembi as well, about 3,000 or so. So sometimes it happens, it's the way of life. That those who need protection of their rights the most are the ones who can least afford it. And that's where public interest litigation and pro bono action becomes important. I think we've already mentioned the remedies that the courts can give, that can come from the administrative mechanisms as well. The businesses can be obligated to cooperate in effecting the remedies. In the Owino Uhuru case, the lead factory was ordered to clean up the environment. And NEMA, the Kenya's National Environment Management Authority, has a role in that process as well. The businesses can be obligated to apologize, to give restitution or compensation, to rehabilitate the environment, for example, and to give financial or non-financial compensation. And they can also face punitive measures like fines or other sanctions. In terms, just to highlight again, some of the mechanisms that are available, we can take action within the national jurisdictions, national courts, the High Court of Kenya or Uganda, or Rwanda or Burundi. But then we also have the regional mechanisms, which Praise is extremely familiar with and an expert at. The ESCJ, for example, we have the African Court on Human Rights also as an available mechanism for some of these action. And then at the international level, we also have the UN mechanisms, though each of them having different rules on standing and jurisdiction and the remedies that they can give, as well as other aspects like what course of action can one take to those mechanisms. Let me close by a recent case we did for the Law Society of Kenya, when the government tried to implement something called the device management system. They bought a system that was meant, they said, to identify fake phones. But then this system could also tell someone's geolocation. It could access the call records. And so the Law Society of Kenya tried to take that case to the Supreme Court of Kenya on appeal. But the court said that because LSK was not a party at the lower courts, it had no standing to bring that case, though the Law Society of Kenya has a statutory mandate to assist the public, and the case itself had been filed in the public interest. So standing is one of the issues that people will grapple with when trying to enforce the obligations of businesses. The standing question has also recently arisen in the Coca-Cola case. Someone who said that I used to drink Coca-Cola, but I stopped on the advice of a doctor, brought a case saying that when I look at the Coca-Cola in a glass bottle and the one in the sold in the plastic bottles, I can see a difference. The one in the plastic bottle supplies information that benefit consumers. But when I look at the one sold in glass bottles, there's missing information. I do not see the nutritional information or the contact address for me to complain. And so he took a case to court. Coca-Cola tried to argue that, look here, this person has admitted that they no longer consume the Coca-Cola drink, and so they have no standing to sue. But the Court of Appeal recently in Kenya held that one could sue in the public interest and also as a member of a class on behalf of a class, the class here being consumers of the Coca-Cola beverage. And so standing is one of those issues. The other could be costs, also as a structural barrier to accessing remedy, and that's where pro bono or public interest litigation comes in. Thank you. Let me wait for the questions.
Thank you so much, Mr. Ochiel. Thank you for giving us a clear background of where we have seen litigation on issues of business and human rights. The good thing you have highlighted how we have litigated in different areas, both national courts, regional courts, but also international courts, which give us an understanding how we lawyers can take part in issues of business and human rights, and mostly we litigants. But as stated by other panelists too, it's important that before we reach that stage of litigating, it is upon us, the legal profession, to ensure that we provide clear advice to our clients, but also to the state or the corporation, so that we ensure that they link their work or their activities in nexus with how they should protect human rights, so as to ensure we don't get the aftermath of us having to go to litigate the case. And having said that, I think this is the right time to bring the participants on the floor to ask questions, but also to contribute to different ideas on how we as the East African region citizens can improve and ensure that our states and our corporations protect human rights. With a show of hands, I'll look through the participants and see who is ready to contribute, where I can also see that some of the participants have also contributed in the chat on how best we can improve. As I'm looking through the participants list, I'll read through the contributions in the chat, where as lawyers, we can also contribute through research and development in the area of human rights and business. And also we can contribute towards popularizing the National Action Plan. That's a good area that most of the legal profession can undertake as an initiative to ensure that our states are also aware of the existing laws, but also citizens are aware of what is incorporated in the National Action Plan so as to implement it effectively in their activities. With a show of hands, I welcome the participants for contribution or questions. Welcome. Okay, I see a question from Sandra. She's asking, how possible is it for human rights abuse victims of multinational companies to seek legal remedies in local courts? So I will take a round of 4 questions or 3 questions, then the panelists can respond to them. Another question is, how is it possible to apply any remedies awarded in local courts against the multinational corporation? As we wait for other questions, I will welcome panelists to respond to that. Mr. Ochiel, do you want to go first since you are the last speaker?
Thank you. I think that's something we've quite struggled with in the Facebook case, but then up to now, Facebook refuses to be served, though the file for stay of execution, I think most of us may be familiar with that, perhaps with the exception of Rwanda, which is Francophone. Most of us might know what a stay of execution is. And so the question we were struggling with, especially for the Ethiopian failure to moderate case, was how do we file a case in Kenya on behalf of an Ethiopian citizen against a company which is not incorporated in Kenya? Facebook says in the court case, in the court papers, I can't go much into the merits because obviously it's sub judice, but it says that, look here, we do not operate in Kenya. But then the Kenyan judiciary has a Facebook account. And so that's a question we are struggling with. And we approach it from the perspective of a tort. If, let's say, this person had been injured within the streets of Kenya by a person from another jurisdiction, would they not be entitled to seek relief within the Kenyan jurisdiction? And then something that we love to say at Katiba Institute is that always do it. We'll always file the case for the court to decide whatever it decides, and then we use that, go on appeal or argue a point. Always use the case you have to develop the law. You'll never know unless you take the case forward, you make the arguments, and then the court decides. So in short, the answer is yes, it's possible to file those cases based on the rules of jurisdiction that would apply to other courses of action. I think we already sue foreign companies within our local courts for breach of contract. We can do the same for violation of human rights by multinational corporations. And the second question is quite important, because if you don't struggle with the first bit of it, when you're preparing for the case, if you don't identify how you're to bring this multinational corporation within your jurisdiction, the rules of service, then obviously you'll run into the second question on how to execute against the multinational corporations. So I think the two are related. The answer to the first should be yes, it's possible to bring them within the local courts. The answer to the second question is that once you identify how to locate them within the jurisdiction, then execution, I think, would not be as problematic. But you need to struggle with the first jurisdictional aspect first, see whether your rules allow service out of jurisdiction, or whether the multinational corporation has a subsidiary or trades or as an office or assets within your jurisdiction. Thank you, Praise.
Thank you so much, Oshil. Also, to add on to that, it has been also very difficult in the issues of implementation, especially also in cases that have been taken into regional courts. So it's also upon us as legal professionals to ensure to create sensitization, but also push our state to create implementation of such decisions, especially where the decision is against the state. And one of other decisions, for example, that Tanzania has experienced, it's the African Barrick Gold Mine lawsuit that was instituted in Canada. So we also have the challenge of how now we can also implement foreign judgment within our country. So that's among the areas that we as legal profession need to look into and identify how we can support to ensure effective implementations of decisions, especially touching on business and human rights. And also, but I can welcome other panelists. They have an addition to the question or response to those questions.
Thank you. Praise God. Just one addition. I think flowing from the thinking in the United Nations Guiding Principles on Business and Human Rights, which basically codify a number of international obligations. If we look at it strictly from the role of the state is obligated to protect its citizens against human rights violations, even those that are occasioned by third parties, and these would include the businesses. I have seen cases where the state has been sued for its failure to adequately regulate the actions of the business sector, especially in the regional human rights mechanisms. Dudley has already highlighted what is happening in Kenya. The Kenyan courts have ruled that they have jurisdiction, even though the questions are matters pending appeal, but the courts have already ruled that they have jurisdiction in some of these cases, even when the business in question is not strictly incorporated in Kenya. I remember the Ogoni case that was filed with the African Commission, and it was against the Republic of Nigeria for its failure to adequately regulate the activities of Shell, which is a foreign multinational corporation, because its activities or its actions were affecting adversely the rights of the Ogoni people. And the finding was in favor of the community. So I would agree that it is possible, both locally and even regionally, especially if we approach it from also the obligation that the state has in terms of protecting us against those third-party interferences on our rights. Thank you.
Praise, are you on?
Yes, I'm on. I was waiting for you to speak.
All right. Oh, okay.
Yeah.
Okay,
welcome.
so thank you, my fellow panelists. I think I'll just want to add to what Sandra Rugaita asked about how possible is it for human rights abuse victims of multinational companies to seek legal remedies in local courts? Yes, just to add on to what my panelists have rightfully stated, I think I'll just give a view of some of the ongoing projects, for example, in oil and gas or the infrastructure project. So you need to understand, or even when advising such victims, that number one, before these projects are undertaken, they are required to undertake what is referred to as environmental, social, and impact assessment study. So this is the first document that holds these companies accountable. So this study is it's really a 360 assessment of the impact of the project on social aspects, around the project. If it's displacement, if there's going to be resettlement, then the study will require a comprehensive resettlement action plan. If it's issues around environment, if their water body is going to be affected, if it's trees, if it's the climate. So this is the first document that I would advise in case you're dealing with a client who has experienced this. So the social even covers labor, what is the plan around labor? How are you going to ensure people, especially the communities, the host communities of the project, how are they going to, first of all, benefit? And, in case anything happens, the risks, happen, what are the mitigation plans? So ideally, what we need to take home is that there is a study, a detailed, actionable study that the companies are required to undertake. And then these studies are supposed to be, they're supposed to be actually a public hearing, and then everything within there is disclosed to the communities. And the communities have a chance to ask questions and, kind of really understand the details of this project. So my advice is, when you experience this, and I'll just talk about my experience because I've done a lot of infrastructure and project work. It is the first document. These days, the in-depth of the study goes up to human rights assessment studies, where you actually take a deep dive into human rights and have an actual impact assessment on human rights. Now, if this document has, provided for those instances, because any abuse must have been provided for, whether it's labor, social, being displaced, that document should detail all these things. And so before you run to the local courts, the first instance would be the company itself. I know it sounds a bit, out there, but I'm not a litigant, I'm an ADR practitioner. So I always look for the quickest way we can solve this dispute. So the company would be the first point. And this document is a public document. The national environmental agencies would have it, the districts would have it, the nearest local authority would have this document. So the lawyers is to take time, read, interpret, and be able to use this document to hold this company accountable. Ideally, once anything manifests and this document has provided for the impact of the assessment and what the remedies would be, then it is easy to just hold the company accountable and then be able to compensate as required within the document. If the document for some reason has missed this specific impact assessment, then it is an opportunity for this to be brought to the table between the company and the victim of the human rights abuse. If this is not addressed, then you can now seek for the other tiers of remedies. For example, in Uganda, we have the Human Rights Commission. And my point here is, let's try to think of more effective ways we can get solutions for our victims. Sometimes, you run to courts of law. It might be a problem that is very highly technical. You require tests, you require this. By the time you align the different government entities to come, and the movement of all these, laboratories, go to geological, go to whole time, the time value of money. And so you find people in court, victims of human rights, give up because they are spending 3, 5, 10 years in court over a matter. The issue even passes. Sometimes even projects, run their life and close, and victims are still in court. So the spin I'm putting in this is that in as much as it is important for remedies to happen, let's really critically understand the chain or how best we can achieve these remedies for our clients before we seek for court redress. But yes, court redress is also there. It's important, but there are more accessible ways that we can still get the same solutions. Thank you.
Thank you so much for the response. And as elaborated, looking at also further comments, they're linked to the responses of the previous question that was raised. And the question was a human rights remedies or preventative mechanism. So looking at the response that the panelists were responding to, it was on issues of what existing remedies or if the remedies are effective and can be implemented in our national code or national jurisdiction. So I will I'll start again with the last panelist was just finalized speaking into responding. So are human rights remedies or a preventative mechanism? So how are we going to deal with this? Looking at the question, the impact that has been done by different business corporations or states that affect the citizens of a particular area, then how are the remedies going to encounter? Will we take it as a preventative mechanism or will we take it as human rights remedies as it stands? Asmane, I welcome you.
Praise, is it me to go first? Sorry.
Yes.
Oh, okay. Thank you. In my view, human rights remedies. Well, I would want to say there is two sides to this question. And I would say it would be a remedy where there is no awareness. And that's why from my presentation and all the panelists have shared is the importance of awareness. So if there is proper awareness through all these structures that you're talking about, from government to stakeholders to support the awareness, then it ceases to become a remedy, but rather a preventive mechanism. However, where there has not been awareness around protection or business and human rights, and these rights are infringed on, and even the victims are not aware. I'll give you an example. You find that sometimes, communities coexist with projects in such ways that are so dehumanizing. To them, it is okay. They are able to do 1, 2, 3 things. The compensations are not, in accordance to the actual standards, For some of the projects here in Uganda, for example, the oil and gas project, the standards that are applied at the IFC, the International Finance Standards, So there is a standard, and actually what the project requires is that, in as much as the national standards guide, if the IFC standard has the higher requirement to compliance, then the project adopts the IFC standards. So you can see that, there is already a standard approach. There are some projects where you find that people are not aware about their rights, and until NGOs or, some association or lawyers come in and make the awareness, and then, people are all of a sudden, okay, we have been displaced, we have been done. So there, in my view, it becomes a remedy. So for me, the way I see it, it all starts on information democratization to make sure And I saw one of the comments that even us as lawyers, we have a role to play in ensuring that the awareness, people are aware, communities are aware, the national task forces, that action plans that are there, people are aware, so that then they are preventative mechanisms than when the infringement happens, and then we have to seek remedial action. Thank you.
Mr. Cyrus, welcome. For any response on that?
Thank you. I look at it both ways, in that when you remedy, in a way, you're also preventing that violation from reoccurring. And if you look at the spirit of the United Nations Guiding Principles, it contemplates guarantees of non-repetition as actually one of the remedies that can be given over and above what we already know, and over and above the remedies that we seek from either the courts or the administrative mechanisms. Again, if the administrative mechanisms are functional, part of what they are supposed to look at is to investigate and punish the violators. If that be done, in a way you are redressing what has already happened if you focus on the present, but you are also futuristic in looking at how best you can prevent some of those violations from reoccurring in the future. So my take is this, it depends on how you look at it, but it can be both. You prevent as well as you remedy what has already happened. And even in court, it is expected that once a court has pronounced itself, once members of the public and even the businesses and even the states get to know that certain violations will attract certain sanctions, then that is also in the long run likely to affect how they conduct their business, and they're likely to avoid some of those scenarios that present these violations with, of course, adverse, and especially for the business, the costs that the courts are likely to award should also be something for them to think through and in a way act as a preventive mechanism for future violations. I would invite participants to look at the commentary to principle number 25 of the United Nations Guiding Principles on Business and Human Rights that clearly provide that one of the remedies is guarantees of non-repetition. Thank you.
Thank you so much, Mr. Cyrus. Mr. Phil, I welcome if you have any comments before I go to other comments and questions in the chat.
Well, I just concur with Cyrus on that. I think it's both because of the protect, respect, remedy framework that we've spoken about. Protect and respect are preventative, and then remedies, address any harms that occur. But I also owe a colleague this obligation. I have a friend called Joyna who is in business, and she's saying that why am I not seeing business representatives in the talk? They're the ones to comply with these obligations. So I would maybe just perhaps inquire if there's any of us who's in business and the approach they're taking towards this issue. Are they doing human rights impact assessment? Have they been sued? What are they doing to help comply? Thanks, please.
Thank you so much, Michelle. And before we look for the business perspective within the participants and also within anyone who is in here, including the panelists, let's first look at the question raised in the chat, especially from Mr. Sir Abraham, where among the issues he has inquired on how we are dealing with local standards in East Africa, and given experience in Nigeria, where the issue of local standard has been watered down to allow rigorous public interest litigation. So how are we as the East African region dealing with issues of local standard in our court? And I'll welcome the panelists to speak in their perspectives in both Uganda, Kenya, and also other parts of the region in which they have had encounters and litigated upon. But since I'm speaking, I'll take the initiative of giving a brief about Tanzania, where I come from. And for Tanzania, with our recent amendments of our laws, the issue of locus standi has been strictly limited, especially on issues of public interest litigation. So for us, someone has to show that they are personally affected with a particular issue. So if I can't show that a particular corporation activity has directly affected me in whatever they have done, I can't take that case as a public interest case. So that has really limited the public interest litigation in Tanzania as a general, and where that's how we thank the existing of the regional courts, in which we can now take our litigation to the EACJ, in which is the most closest court because of the no limitation as to exhaustion of local remedies. But then with this, it has been a really challenge on how people can use the platform of public interest litigation in Tanzania into taking cases. But as legal professions, we don't relax, we litigate, and to ensure that these challenges we can encounter them and see how we can protect the citizens of the country, because lack of awareness also makes people not litigate these cases. So one can be personally affected, but because they're not aware of those existing rights and the avenues they can take, they don't do any action. So it's upon us, the legal profession, now to go either create awareness, but also assist them, as Ochiel said, through pro bono cases and how we can support them in mitigating these cases in court. And since Ochiel, you're the one I see on my screen, I welcome you to respond on Mr. Sir Abraham's question.
Well, I think the Nigerian situation is what the Kenyan constitution intended. It allows you to file a case in the public interest. It begins with you for your own behalf, then in the public interest, then on behalf of someone who cannot file that case themselves, maybe because they are under threats or have gone on asylum or for any other reason, or they are minor, any reason, then you can file on behalf of a class of suitors, perhaps consumers of a certain project, class action. And that's why we've taken the Supreme Court decision to the EACJ, saying that in that decision, the judiciary of Kenya violated the law by taking us back to a view of locus which we have long moved from. In the 1990s, Professor Wangari Maathai was told by the court, Justice Dugdale, that she had no special interest in the preservation of a park here in Nairobi called Uhuru Park, so that she had no right to go to court to sue to prevent Kenya Times, a newspaper, a company, I think, where the president then had interest, from building a tower in that park. So we moved from that perspective. Our standing now is broad, and that's why we are not quite happy with the Supreme Court saying that for you to appeal in a public interest litigation, you need to show that you have suffered personal harm, private harm, before you get standing to sue before the Supreme Court of Kenya. So we are waiting for the EACJ to hear that case. We'll see what it says about that. Thank you.
Thank you, Chair. I'll welcome the next panelist to give an overview on that particular issue of locus standi in relation to the EACJ region. Ms. Asman.
Okay, can you hear me? I think I'd been muted. Praise,
Yes,
can you hear me?
Yes, I can hear you.
Yes. Yes. So from the Ugandan perspective, I think it's more or less what has been shared with Kenya. However, there is an interesting case that was filed in I think that was this was what, about 2013 or so, around there. I forget the year. And this was a public interest litigation. It was filed actually in our High Court, and it was the plaintiff was the Africa Institute of Energy Governance, called AFIEGO, and it was brought on behalf of displaced persons for the the refinery project that is being undertaken in the Albertine. So the issue came up on locus, whether, this institute had the right to bring this matter before court. And the institute was representing, I think there were about, the complainants were about, they were in thousands. Unfortunately, the court ruled against AFIEGO, and they lost that matter in that regard, for the fact that, they didn't have locus to bring this matter before court. The matter went on to move. I'm not, well, I don't have the detail where it is now. It could be in the Court of Appeal or to Supreme Court. So we haven't had, a stand on it for now. If anyone on the call has the actual, the current status of that case, but the last I followed up on this, it was, I think they had appealed, and I'm not sure if the ruling is out yet. So I think that's the test that Uganda has had in regard to these business and human rights, because this was very specific on the impact of this project on the project affected persons. Yeah, so I think that's what I can practically share. Yeah, I don't really have any other example. Back to you, Praise.
Thank you, Mr. Asmahan. Maybe I welcome Mr. Cyrus, if you have any experience of other countries, or what are your contribution on the issues of local standard and how it can contribute towards promotion of and protection of business and human rights.
Thank you, Praise. Dudley and I are from the same country. So it's the same position in Kenya, where our constitution is liberal enough to allow even persons who are not directly affected by a violation to challenge that violation in the Kenyan courts. And one actually need not demonstrate how they have suffered from that issue or from the violation that they are complaining against. So it's liberal enough in Kenya, and we've had cases that have been filed even by civil society organizations, even ourselves as the National Human Rights Institution. There are cases that we have instituted in our name or in the names of Kenyans, but brought in the public interest to assert various rights that were being violated, even when these organizations are not directly affected. I think that's what I would say. Thank you. Back to you.
Thank you, Mr. Cyrus, for that, and thank you, other panelists. As well indicated, most countries, the issue of local standard have left it to the broad so as to accommodate the issues of public interest. And also having the existing of regional courts, it's also a platform where we as the legal profession can utilize towards effectively ensuring the protection of human rights and the nexus between business and human rights. Before delving into this, Mr. Ochiel had inquired as to whether we can have the business perspective or from corporate line into identifying how or what initiatives as corporations have undertaken or are undertaking towards implementation of these guiding principles on human rights, but also different action plans within the countries towards protection of human rights. And as said by Ms. Asman, it can be that we as lawyers also own specific business, and as she clearly said, she also owns a law firm. So it's how now we undertake as lawyers towards protection of human rights, and what angles do we use to ensure that we abide to the existing laws, but also existing guidelines. So I'll welcome any participant who can give their overview, but also panelists who can give an overview of how best the business angle is undertaken towards protection of business and human rights. Ms. Asman, do you want to give us an overview of how best, if you have personally interacted with that, or even if your clients, and how you have best advised them on issues of business and human rights?
Okay, thank you. Praise God. So I thought the participants would, just share their views so that it's more interactive. But like I said, I think I'll start with a very practical application through the business we run as a law firm. So of course, generally, there is the general legal compliance, for the Employment Act, the Workman's Compensation. But I think the most important thing is the general awareness that, the business interacts not only with just people, but, the surrounding around people, the environment, and all existing, the whole ecosystem around the people. But to start with the people, I think there are initiatives. We run initiatives, of course, employment. We ensure that the employees take their leave, all sorts of leave, so people can have time to rest from work. Every quarter, we run a quarter leave system. At least there is a rota that we run, and, very, very intentionally track it. People should go home, rest. We also have work from home initiatives, maternity leave, paternal leave, and all these things. Then the other aspect of it is compensation. People, with employment, people should be paid on time. What are the other benefits that come with a job? So some of those things, it's really recognizing the economic rights around people, participating in employment. Then, of course, the other things is the occupation health and safety. The premises that we have, we are constantly aware of issues around how we occupy it, generally running a clean environment, health issues, with the COVID that came up. At least it became a very, highlighted aspect that health actually is a very, very critical component of business and human rights. So, just ensuring that people sanitize, the health around, we every 2 to 3 months, we fumigate the office and make sure the space is healthy enough. There is water, things, small things like that. But you see, you're running through the occupation health safety. Of course, the building is secure. When people come in here, there are security checks. We have cameras monitoring, movement in and out to ensure people are protected. And anything happens, we can be accountable. So those, I think, are some of the small initiatives. But also now to take it to the other level, it also goes to policy. The awareness, like I say, for lawyers who have access to boards of these corporate companies, is to start that conversation, Sometimes they're embedded within the overall policy, but to see that these things are highlighted and made critical. Specifically, my business, we run a green campaign. Yes, lawyers, we print and use a lot of paper. But part of the things we're doing now is to just be aware of the environment. Must you print that? Are we able to collaborate better with technology like Microsoft 365? Can we collaborate and not print? Good enough these days, our courts have the ICMIS system, so you can file online, and I know in Kenya as well, there's a lot of online filing. So that is just awareness, because most times paper, it really adds carbon emissions to the environment. And so, you find that this is, like I said, for me, a lot of business and human rights emanates from awareness. Sometimes people do it not knowing, as business as usual. But if you're aware and very intentional about it, then really you're incorporating the aspects of business and human rights. You're really marrying these two together, and it becomes business as usual. Then interacting with clients, of course, it's very important, you know. Like I say, these days, the ESG agenda is out there. Everyone is talking about ESG, you know, issues around discrimination, the female to male ratio, male to female ratio. Is there equal opportunity in terms of hiring? You know, what is the recruitment process? Is it transparent? You know, just these small issues that come up, you know, that can be viewed as discriminatory, you know. Age, you know, these days we all have a young population in this generation. So regardless of the age, people getting the right opportunities. And also, if you hire young people, do you have a conducive environment for them? Do you have training, mentorship, coaching opportunities to see that they fit well within their environment and can enjoy their economic rights? So there's really a wide-based approach to it. But for me, my take home is it's important to be aware. And from that awareness, then you become very intentional about what you're implementing. Because if I'm to project into the future, with the campaigns around climate change, the greening up and all these things, it will no longer be, you know, just something that you may or may not do, but eventually it will be one of those things that become actually an actual risk for businesses if you're not compliant, because then you don't have anyone who wants to work with you. So I think it's important that we run these campaigns, we are aware, and then be able to implement, but also track and be able to demonstrate that you are doing these things. So yeah, that's what I can share for now. Thank you, Praise. Back to you.
Thank you so much for that contribution. And looking at the time, we're already out of time. I'll welcome the other two panelists, starting with Mr. Cyrus, then Ochiel, to give a round of conclusion, 1 minute, if not 2 minutes. Good. Thank you. Mr. Cyrus, welcome.
Thank you very much, Praise, and thank you to the participants as well. Business and human rights is a discussion that we need to continue having constantly. For the business, it is about what narrative we are telling them. The discussion is not creating any new obligations, but it basically trying to help them look at how best they can conduct their business, minimize litigation, and minimize a few other issues that may not go well for their business. My parting shot is that much as the business of a business is to be in business, that business will not be any sustainable if a business engages in human rights violations. We've seen cases where companies hire human resource managers to advise on the human rights components, how best they can recruit staff, how they can retain the staff, and how best they can disengage with those staff. It is also time for the businesses to consider hiring human rights advisors to walk them through the journey and enhance their compliance with business and human rights. Thank you very much.
And thank you, Praise, and my co-panelists for the opportunity. I think I've learned quite a lot. Thank you, Justice George Will, for the perspective from Nigeria. My takeaway is something as Maan said, that as law firms, we can also begin introspecting and implementing the ESG framework, see how we treat the people that work for us, the people we work with, and our clients from a human rights perspective. I'm grateful for the chance. Thank you.
Thank you so much, Ochiel. And looking at what we have engaged and how the presentation and the comments from the participants are, it shows how we as the legal profession have a lot of things or a lot of work towards in ensuring that business and human rights is well implemented within the East African region. And before concluding our webinar, I welcome Mr. Gabriel for comments. Mr. Gabriel, welcome.
Thank you so much, our esteemed moderator. Praise God, and also a huge thank you to our esteemed panelists, Ms. Asmahani Sad, Mr. Cyrus Maweo, Mr. Ochil Dudley, for sparing your time to speak to us on this very interesting subject. I have been following closely, and I have also seen the enthusiasm exhibited by the participants on this session and online. We have been streaming on Facebook and live on YouTube. And I would also like to thank our participants on those. My apologies, some small glitches here, but I would like to thank our participants on those various platforms for joining in on this session. I would like to also thank the Business and Human Rights Committee, led by our very able chairperson, Mr. Gatambia Ndungu, for his stellar leadership and for organizing this. And I cannot forget our partners from FOID, Mr. Patrick Karanja and Ms. Sarah Ngachi. Thank you so much for putting this together. Participants will be giving out certificates, and we'll also share a recording of this session as soon as we have it extracted. I just have a few announcements from the Secretariat of the East Africa Law Society. And the first one being the East Africa Law Society is convening the biggest gathering of in-house counsel within Eastern Central Africa, dubbed the In-House Counsel Convention 2023. This session is happening next week on the 27th and the 28th of July 2023. If you know you are in-house counsel and you've not yet registered, I would like to call upon you to register because majority of in-house counsel have registered for this event, and they'll be gathering in Zanzibar at the Al Madinat Hotel. So you can get more information on our
You seem to have lost Gabriel.
Yes, we have
Is it
lost
just me? Oh, okay.
No,
Okay.
we have lost that one. We give him some few minutes. In his back.
Yes, Yes, so we'll be in Bujumbura. Sorry about that small technical glitches. We still have more information on our website. Otherwise, I would like to thank you, and we look forward to hosting you in Zanzibar for the in-house council convention. Please get more information. I see Zeda Mkwazu, your hand is up. Would you like to speak? Ziada Mkwanzu? Okay, all right. So if that's the case, then we'd like to thank you for being part of this webinar session. I would like to thank our panelists, and over to you, Madam Moderator, to officially close the session. Thank you, and apologies for my bad network.
It's okay, Gabriel. Thank you very much. I think you have made the right conclusion for me to add anything. But all in all, I want to say thank you for everyone for joining, and please look forward to other webinars, other knowledge exchange and building capacities from ELF. Thank you, everyone. Have a good day.